The rules for artificial intelligence moved from theoretical warnings to hard, enforceable law. On August 12th, the concept of mandatory friction officially hit the books. The legal baseline was set here. This is the Colorado State Capitol, where House Bill 26195 took effect to regulate how machines interact with patients. The statute explicitly forbids an AI system from conducting psychotherapy unless 3 distinct parties are present in real time. The licensed clinician, the machine, and the patient must all interact synchronously. If the human professional isn't actively in the loop, the AI cannot run the session. California lawmakers wrote nearly the exact same standard, but instead of passing it, the state assembly parked the 39-0 bill in a suspense file. That is a procedural room where legislation can quietly expire without any politician having to put their name on a recorded no vote. Managing that mandatory oversight in a high-stakes clinical setting is exactly why today's Spencer, Clinician Assist, built their platform to keep the professional directly in control of the AI. While Colorado successfully established a strict legal boundary requiring a human checkpoint in therapy, the broader technology industry is accelerating in the opposite direction. They're pushing artificial intelligence into deeply vulnerable spaces with zero mandatory oversight. Take the infrastructure of public education. Inside Google Classroom, a platform utilized by more than 150 million students and teachers globally, Google suddenly switched on its Gemini chatbot for elementary and high school students. They didn't ask schools if they wanted it. The rollout operated on an opt-out default. Administrators in multiple states found out the AI was active from outside channels, forcing them to scramble to find the dashboard controls and shut the systems down. When platforms remove the restriction of affirmative consent, they leave the door wide open for their youngest users. A federal lawsuit filed in Northern California illustrates the extreme consequence of that approach. The complaint details a Kentucky girl who opened a chatbot account on Character.AI while at school. She was 12 years old at the time, and her parents had no idea she was using the service. The structural failure of the platform's onboarding process is documented right here. Paragraph 267 states explicitly, Character.AI never asked plaintiff to verify her age. Building an account creation screen without an age gate is a deliberate design choice. When tech companies assume consent by default, they completely bypass the human checkpoints needed to guard their most vulnerable users. The effort to strip away those human checkpoints is heavily coordinated. The federal government established an AI litigation task force inside the Department of Justice, armed with a specific mandate to challenge state-level AI statutes. Industry lobbying groups are matching that pressure in state capitals. The Computer and Communications Industry Association actively urged a veto against Vermont's strict prohibition on AI mental health care. They lost, and the governor signed it anyway. Having lost that fight, the same trade association is now heavily marketing a different template to lawmakers across the country, Nebraska's LB 525. It is a lighter model that requires only basic safety disclosures, entirely omitting Colorado's mandatory human-in-the-room requirement. The strategy is straightforward. The technology sector wants to legally replace active, synchronous human oversight with passive, easily ignored warning labels. That lack of oversight creates an immediate crisis for the criminal justice system. In Acton, Massachusetts, a 17-year-old is facing trial for the deaths of his mother and 14-year-old brother. Investigators extracted his conversation history with ChatGPT. The prosecutor characterized the prompts as Gothic novel fantasy stories, written in the third person, regarding a character killing his family. This presents a massive evidentiary problem. A person drafting a fiction scene and a person planning an actual crime will type highly similar language into a chatbot. The machine processes both inputs and spits out the exact same digital artifact. Without a human present to contextualize the text, the transcript alone cannot prove intent. Prosecutors and defense attorneys are left guessing based entirely on a black box output. The courts simply do not have an established standard to evaluate these documents. Because there is no human checkpoint in the generation process, our legal institutions lack the basic tools to interpret what an AI artifact actually means. Contrast those automated failures with a system where the human refuses to surrender control. An 80-year-old Marine Corps veteran, identified in reporting as Chip, used ChatGPT to help draft a supplemental disability claim for Agent Orange-related cancer. Chip treated the machine as a starting point, manually proofreading the draft multiple times to verify every symptom before signing his name. His personal verification secured a 100% disability rating in 6 weeks. Even the massive bureaucracy of the VA operates with the same underlying philosophy. The agency runs a separate $485 million internal AI built by IBM strictly to sort evidence and generate claim summaries. But that software is explicitly forbidden from deciding cases. By agency rule, an actual human rater must make the final decision on every claim. To ensure accuracy, human quality specialists routinely pull files to manually spot-check the machine's summaries. The legal requirement of the handoff is the defining battle of the AI era. Forcing a machine to pause for human verification determines whether society remains in control of the outcomes AI produces.